Welcome everybody, my name is Norah Gallagher and I'm here to give you some further details on the Energy Law Principles module. I've been teaching at Queen Mary since 2002 on actually a range of modules, from everything from investment treaty arbitration to energy law. And this Energy Law Principles we've actually been teaching in some form or other since we actually set up the Energy and Climate Change Law Institute 10 years ago. So it is considered to be a core module. Not just for energy students. Generally, we have a lot of students from commercial arbitration, international business, and some from dispute resolution, because obviously energy is the largest industry in the world and it impacts pretty much every other sector. And this is particularly true in the last decade, since the efforts of government have increased to try and tackle the climate crisis. So the energy sector is being impacted most by that energy transition, but indirectly all other sectors are impacted by it. So the Energy Law Principles module is really, I suppose, the fundamentals of energy law, the historical evolution and development and some of the seminal arbitrations that came out in the 1950s and 60s in the Middle East, in the expropriations, in the Anglo-Iranian Oil Company, the evolution of Lex Petrolia, and it really has a very firm focus on the specific contracts. So it looks at the application of hard law, so treaties and national laws related to petroleum and extraction, as well as soft law instruments like the United Nations Guiding Principles on Business and Human Rights. It also explains to students the market drivers. So what is behind the whole energy sector? What is the impact of the energy transition? What is the impact of the growing number of disputes that are being filed both in arbitration and in national courts to prompt states to make further changes and reduce their CO2 emissions and, in fact, move away from power generation by fossil fuels. A very well-known case is the Urgenda versus Netherlands case, where the Supreme Court in the Netherlands said, yes, you, the government, are not doing enough and you need to do more. So this is impacting governments, but it's also impacting states. So after we have a look at the main granting instruments, we also look at one of the fundamental contracts used in the energy sector, and it's very specific to the energy sector. It's the Joint Operating Agreement, which I like to call, it's almost like a marriage contract between the parties where competitors come together to exploit a particular field for many reasons. It's very expensive, it's long-term, it's very risky. I've had cases that I've been involved in where they drilled 2 or 3 very expensive boreholes and they came up empty. Or they come up with some oil or gas, but not enough, not sufficient for have to be in commercial quantities. So there's a huge amount of risk that they prefer to spread around in many different jurisdictions, and that joint operating agreement is at the core of that arrangement. So again, we spend quite a bit of time looking at the main provisions and how that joint operating agreement works. There are some other key provisions, such as the force majeure clause, that we also look at. So at the end of this module, students are really familiar with the terminology and the language used in the energy sector, the market drivers, the future direction, and the main type of contracts that are used in the energy sector. I'm very much looking forward to meeting you all towards the end of semester 1 for the Energy Law Principles module. Thank you.